Dr. Ochab, can I take you, first of all, to 1941 and a radio broadcast by Winston Churchill, who said that there was no word sufficient to describe the monstrous crimes which had occurred in the Holocaust. And it took a Jewish Polish lawyer, Raphael Lemkin, who'd lost over 40 of his own family in the Holocaust, to give us that word, genocide, the cutting of the human family. And great hopes were held out that the Convention on the Crime of Genocide, the 75th anniversary of which we're marking this year, would somehow stop what Pari Ibrahim said earlier on in her excellent contribution, would stop it happening all over again. And yet from Rwanda to Bosnia and many other places, we've seen it happening again and again. Can you remind the Joint Committee that apart from the words like predict, prevent, punish, apart from those words, what are the actual detailed obligations under international law that fall on the United Kingdom to try and prevent these atrocities from occurring?
Thank you very much. So, of course, we are talking about the Genocide Convention, which not only defines the crime of genocide in Article 2, but also imposes obligations upon states to prevent and punish the crime of genocide. And starting with the duty to prevent genocide. The convention itself does not explain what it means, how this duty is to be implemented, but there is a very important judgment from the International Court of Justice from 2007 that talks about what actually prevention means. And paraphrasing, we don't have to wait until we see bodies on the streets, because then we are not talking about prevention. We have to act much, much earlier. And the Joint Committee, the International Court of Justice confirmed that the duty to prevent arises at the instant a state learns or should normally have learned of a serious risk of genocide. And that is the trigger point for the duty to prevent genocide. And unfortunately, that's one of the duties that is not implemented pretty much anywhere in the world. Because in order to implement this duty, states should have domestic mechanisms that will enable them to identify early warning signs and risk factors, to identify situations at serious risk of genocide in order then, of course, to trigger the duty to prevent genocide. And, for example, in the UK, there is no such mechanism. This was recommended recently in the Bishop of Truro Review to ensure that there is a mechanism for early monitoring, early warning signs of atrocities to come. In response, the government established a small team of, I believe, 3 individuals who are monitoring the situation, but unfortunately, we don't see any result of this work at this stage. And then, of course, the government has this joint JAX assessment, which is joint assessment on conflict and stability. But unfortunately, this assessment is not available to anyone. It's only for government's eyes. So even this place, the parliament, cannot check whether the government is actually following its own advice identified in this assessment, which is very, very concerning. And at least parliamentarians should have access to it, to know, again, whether the government is doing what it's actually identified for itself to respond to atrocities. And then, for example, in the US, there is definitely much more work being done in relation to monitoring early warning signs, especially with Elie Wiesel Act. That was adopted some years ago, and there is annual review of situations at risk, situations of concern, and also identification of the steps taken by the US government in response to those situations, which provides more clarity, provides more transparency as well. It's not perfect, but nonetheless, this is a great start in order to implement the duty to prevent genocide. And then very briefly on the duty to punish genocide, the second duty incorporated in Article 1 of the Genocide Convention. The duty to punish genocide, of course, requires us to introduce laws that will enable us to prosecute the perpetrators, but also requires us to actually prosecute them, be involved in the prosecutions, and help international tribunals as well to prosecute others. In relation to this duty, of course, in the UK, there is law on genocide. Initially, it was the Genocide Act from 1969. It is now repealed. There is a different law. It's the International Criminal Court Act from 2001. And this law replicates, of course, the wording of the genocide of genocide from the Genocide Convention, which is then replicated in the Rome Statute. And but if we look at the provision, the scope is much narrower in terms of course, it provides for universal jurisdiction, but only in a very limited number of cases. It is more extraterritorial jurisdiction rather than a universal jurisdiction. But I believe we'll be discussing it later.
So if I may, Chair, your recommendation is that the JAX reports that are drawn up for situations such as that in Tigray at the present time, which we know exists, that should be available to members of Parliament at the very minimum, that there should be more transparency. Can I ask you about other gaps in the Genocide Convention? One of them, for instance, around the political classes who are not covered in a country like North Korea, which comes out in the 10th anniversary of the United Nations' own report by Mr. Justice Kirby into atrocities in North Korea, that they are simply not covered as a group. Or during the Daesh atrocities, the killing of homosexuals, the throwing of gay people off buildings, that they are not covered as a group of people, as an ethnic group or a racial group. Is that another gap that perhaps needs to be addressed? And finally, the French have put forward proposals for the reform of the United Nations Security Council, but at least in the case of atrocity crimes, that the veto should not be available to those members of the Security Council. And clearly, with countries like China and Russia sitting on the Security Council, they prevent referrals to the International Criminal Court. So is that something the United Kingdom should be attending to, and is it something we should be supporting?
Thank you very much. I definitely would support the disclosure of JAX, at least to parliamentarians, to make sure that they can review the government's responses. If it's not to all parliamentarians, at least to relevant. So in relation to JAX, I believe that there is a greater need also for some kind of a trigger point when this signs, risk factors were there long time before the war began. The JAX assessment was done first in 2022, I believe, 2 years into the war, not as the war started, not before that. The FCDO waited, or the government waited 2 years to do the assessment of the risks, which doesn't make sense. It just does not make sense. So I think there should be a trigger point in order, for example, if, let's say, the Joint Committee on Human Rights is concerned, or the Foreign Affairs Committee is concerned about this situation, write to the Secretary of State to conduct the JAX assessment, and this should be done within the next, 3 to 4 months, or even earlier, subject to availability, of course. But if there is nothing of this sort, it's a matter of coincidence whether the JAX assessment will be done or not. And again, if this is a mechanism that the UK government is using to identify early warning signs of risk and risk of atrocity crimes, we need to engage with it in a different way, and this is not being done at this stage. So definitely there is a need for a change. In relation to other questions, Genocide Convention and its limitations, of course, Lemkin wanted a very different definition, much broader definition of genocide. But unfortunately, of course, once the drafters came together, and because of the different interests of states at the time, unfortunately, political groups were excluded from the definition. Whether it should be amended, I think that would require a lot of time, a lot of attention, but nonetheless, considering the political targeting of individuals, and North Korea is a great example, this is definitely something to look into. French proposal on the veto, yes, and there is quite some support for this proposal. Of course, it would be only resigning from the veto right in relation to atrocity crimes rather than across board, but nonetheless, this is the way forward. And I do have a counter-proposal as well. If, of course, states are not willing to freeze their veto in cases of atrocity crimes, to have also a procedure, a follow-up procedure, that if something was blocked at the UN Security Council, by default, take it before General Assembly. In many cases, you can't do the same. You cannot establish ad hoc tribunals. The options before the General Assembly are limited, but at the same time, you can do certain things. And a good example is the response to the war in Syria. When the resolution referring the situation in Syria to the ICC was blocked by China and Russia, states came together and tabled a resolution before the UN General Assembly, establishing a mechanism to collect and preserve the evidence of the atrocities. And of course, Syria didn't like it, Russia didn't like it, but nonetheless, there were enough, a good number of countries that supported it. The resolution received a majority, and that is what is required at the General Assembly, and the mechanism was established. And now the mechanism continues to collect, preserve the evidence without even going to Syria, and they've been working with prosecutors in 12 different countries to help with prosecutions of the perpetrators. So this is a good example how the default position that if something at the Security Council doesn't work, let's take it before General Assembly, there is no veto right there. We need majority to proceed with certain steps. We need to be flexible with such situations if one body is frozen because of interests of certain countries.
Thank you very much indeed. Thank you, Chair.
Thank you.